very icy. Are there any changes to the final agenda?
Good morning, Chair and Commissioners. There are no changes to the agenda this morning.
Thank you. Let's proceed to, am I on? Am I on? So there are no changes to the regular agenda. So let's proceed to the first item for discussion. Item 201, cases 15M0127 et al., which is the interlocutory appeal by Constellation Energy Gas Choice, LLC, and Direct Energy Services, LLC, presented by Julie Bielowski, Deputy General Counsel. Julia, please begin.
Good morning, Chair, Commissioners. The proposed order before you today arises from the proceedings in which the Commission is evaluating the retail energy market in the state. In preparation for filing testimony in those proceedings, the parties have been engaged in discovery, and the Public Utility Law Project, or PULP, issued discovery requests on many of the ESCOs that are participating in this proceeding. When several of those ESCOs objected, the Public Utility Law Project brought a motion before the ALJs presiding in the proceeding to compel production of the requested information. The ALJs issued a ruling granting that motion. It is that ruling that's the subject of the interlocutory appeal before you. The appeal is brought by Constellation Energy Gas Choice and Direct Energy Services. Now, for the Commission to entertain an interlocutory appeal, an appeal from a judge's ruling at this early stage in the evidentiary process of a proceeding, it's extraordinary, and it's up to appellants to show extraordinary circumstances to warrant the Commission's intervention at this point. Here, typically a discovery dispute would not rise to that level. Here, however, one of the arguments presented asserted by the appellants meets that criteria, so the recommendation is for the Commission to entertain this appeal. Specifically, appellants assert that the ruling improperly orders the ESCOs to release certain customer-specific data in response of two of PULP's information requests. This would be, according to the appellants, in violation of the Uniform Business Practices, Commission policy, and existing customer contracts. The Uniform Business Practices provide for such disclosure in very limited circumstances, only where it's necessary to facilitate or maintain service to a customer or the customer has consented to that disclosure. Because the ruling would require the immediate release of this information, the extraordinary circumstances threshold is met in this case. So turning to the merits, the proposed order finds that PULP's assertion that it needs this information to support its analysis in this proceeding is insufficient to outweigh the countervailing interest protecting customer-specific, personally identifiable information. The information requests would reveal individual names, addresses, and account numbers of residential customers. It is this type of information that, should it land in the wrong hands, could be used to enroll customers for ESCO service without the customer's consent, a practice that has been a problem in the past. So despite the fact that PULP itself may have a valid reason for wanting to evaluate this information, the proposed order finds that the risk to customers of a more widespread dissemination of this information weighs against the disclosure. Accordingly, the proposed order recommends reversing the ruling, but only with respect to these two information requests, such that no ESCOs would be required to disclose the requested customer-specific information. In all other respects, the proposed order recommends affirming the judge's determination, and I will briefly outline the other arguments raised by appellants in that regard. First, appellants indicate that the judges should not have ruled because it was PULP's obligation to first take the issue back to the ESCOs and try to negotiate a resolution of a discovery dispute before bringing the motion to the judges. In their ruling, the judges acknowledged that that was appropriate for any party to try to resolve discovery disputes before bringing it to the judge's attention. However, because the issue was briefed before the judges, and in their discretion looking at it and the distance between the parties on the issue, they decided in the matter of efficiency to go ahead and resolve the issue. The proposed order finds that is appropriately within the judge's discretion to do. Appellants also challenge the relevance of some of the information requested, and the order before you evaluates the subject matter of each request and ultimately recommends affirming the judge's conclusion that the information requested is relevant to these proceedings. Likewise, appellants' arguments that some of the terms used in the information request are vague and ambiguous were properly rejected by the judges because in the context when you read the information requests, any ambiguity can be resolved to the extent that the ESCOs should be able to respond to these requests. The appellant's concerns that the requests were overbroad or unduly burdensome were also evaluated by the judges, and the judges properly found that they were reasonably tailored to these proceedings. Appellants also argue that they asserted several privileges that they assert should not have been, are grounds for not disclosing information requested in the information requests. However, the judge's ruling did not finally resolve this issue. Instead, what the judges said was that there wasn't enough information to determine whether a privilege was warranted, so they rejected those claims without prejudice for the ESCOs to come back and reassert them. Accordingly, the proposed order finds no relief to appellants on this issue as necessary at this juncture. Finally, appellants object to some of the requested information as outside the scope of this proceeding. Those arguments are identical to issues raised and resolved in the interlocutory appeal by the Retail Energy Supply Association and Direct Energy, which is the next item to be presented today. This order does not reach those issues. I'm happy to answer any questions you have.
Thank you, Julia. I welcome and thank you for the thoughtful explanation and the legal analysis and the analysis of the merits. My own view is that we need to affirm and preserve the long-standing policy of the Commission and, of course, the principles in the Uniform Business Practices to ensure protection of customer-sensitive information. Certainly agree with the reversal of those relevant aspects of the May ruling and agree with the rejection of the remainder of the appeal. Are there any comments or questions from my fellow commissioners?
Just to say that I'm fully in accord with the recommendation and with the chairman's remarks.
Commissioner Berman?
Thank you, Chair. So I just want to make clear we have two items, 201 and 202. 202 is separate from that, and we'll be voting on that separately, and that addresses other issues, including the thresholds issue of jurisdiction, correct?
That's correct.
Okay, thanks. So my perspective is that it is true that it's extraordinary circumstances to take up the interlocutory appeal, but this proceeding itself is extraordinary, and how we're handling things is extraordinary. So from a path forward perspective, I am looking at ways that we can facilitate all parties working together, and ways that we can facilitate the opportunity for helping to streamline some of the data processes and data overload that may be required. I am concerned that some of the tenor of the administrative proceeding has gotten weighted down with back and forth animosity. And I think the threshold issue for me is that it is incumbent upon the parties to attempt to work together before they go to the administrative law judge. Now, I do understand that in this case, the first party who didn't go was Pope, felt that it was not going to be helpful and fruitful. That may have been the case. However, I do want to see that parties are trying, despite the odds, to come up with ways to work together and potentially resolve some of these issues so that we don't continue to get weighted down and the administrative law judges don't get weighted down with a lot of back and forth discovery requests. I do. We've been blessed at the commission when I was a staffer as well as on the commission that despite great odds, we have seen parties who have been in polar opposites when they are challenged to come together and figure out solutions. I think that has been historically something that we can be very proud of. In fact, until a few years ago, it used to be that the ESCO collaboratives and the ESCO process was seen as, while yes, tedious and difficult, it was seen as very worthwhile for those parties who were participating and actually seemed to result in resolution, even when people were, again, polar opposites. So I think that history is something that's important and we should look forward to trying to get there. Now, to the extent that the first threshold issue of the personally identifying customer information, that clearly rises to the level of needing to say that information is not appropriate and shouldn't be discoverable here under these circumstances. And therefore, under these circumstances, I think we are all in agreement that that is appropriate to grant that aspect of the rehearing. As to the others, it falls into, for me, that gray area. And again, keeping in mind that the bulk of the issues are in the 202 order, not in the 201 order, and some of the 202 orders deal with the threshold jurisdictional issues, so we only get to that. We only get to the 201 issues if we think that there is jurisdiction on a lot of the threshold issues. So I'll reserve my comments for the 202 order as to the threshold issues there. But here, one of the aspects is that the time period, the 5-year time period, and asking for data for 5 years. And, whether it's 1 year, 5 years, 10 years, 15 years, I really don't know what the appropriate number is. And again, I leave that to the administrative law judge to figure that out. However, I am mindful of the fact that that may be onerous depending on the ESCO, the size of the ESCO, the number of customers, the amount of time that the ESCO has been operating, and what the rules are for having to keep that information. Whether it's an ESCO or a utility or some other entity, 5 years may be, in some fashion, overly burdensome and actually not get to the heart of the issues of what was trying to be dealt with, to address, to bring back to the commission on the threshold issues. So I would look for the folks seeing if there maybe are alternative ways that they can get there. It also, I think, would be important to know, since the commission and the commission staff has had a robust enforcement process, what information over the years have we had for us to make determinations on enforcement? Because if there are opportunities to obtain some of the higher level information without needing to go to the ESCO through this process, I would like to see that the staff and the ESCOs work on the information that already may be housed with the staff, as well as the information that they've deemed over the years relevant, looking at the enforcement process. However, again, I do understand the need for the administrative law judge to have some flexibility, but to the extent that they are hearing from this commissioner the focus of trying to figure out collaboration and alternative pathways, I think that's important. As to, and just want to pull it up, sorry. As to page 15 and 16 of the order, it speaks of the court standard versus the commission standard, and there is a focus that the court standard adopted a stricter definition for discovery, but under this case, we were looking at our discovery dispute, sharing of evidence under the commission proceeding, which is allows more evidence to be obtained than if they were under the court proceeding. Under the court proceeding, my understanding is it has to really be much more direct evidence that is being collected. Do you want to just make sure I'm reading that right?
That's generally correct. The court rules of discovery now have a new test, and it's, I think most people would say it's not quite as broad as the old test, but that's not the test that's in the commission rules, and we apply the test that's in the commission rules.
Right. No, and I understand that from a legal perspective that the commission rules are broader, but to the extent that, again, going back to some of the basic tenets of trying to work together and be collaborative and actually try to get through some of the issues, to the extent that it may be appropriate to look and take a pause and say, let's at least, while we may disagree on the broader interpretation, to the extent that we all are in agreement on the stricter definition from the court perspective and the court standard, let's at least wrap our arms around that aspect and that data overload, and maybe that could be the first threshold issues that are dealt with from a discovery perspective, which may help to inform some future needs as well that will go there from a discovery perspective. So I'm just offering up some food for thought as ways to, again, I do think that there may be pathways, and like we've dealt in many proceedings with different phases, and looking at what we can wrap our arms around with in the first onset, that may be an opportunity. That subset of information is at least more discrete, and maybe we agree and do things in a more systematic, smaller bite way to get there. So then the other aspect is the vague and ambiguous wording, and essentially the draft order says that the Commission's review of the terms indicates that the words have obvious and apparent meanings when read in the context of the full text of the discovery request and the context of these proceedings, and had often been used by the ESCOs themselves in pleadings before the Commission. So it was denying the ESCOs request that there's an understanding of the vagueness and the ambiguity of the discovery request. I guess we all know what the words are. However, I do think that we ourselves on the Commission and back in the beginning of REV did have focus on what was a product, what was value added, what is the definition of a customer complaint, consumer complaint. So, what's a sanction, what's a fee, what's a penalty. So all of those things may, to my understanding, is trying to have, again, a conversation on what is it that we're actually trying to get, especially as it goes to information and data on customer complaints. What do we ourselves as the Commission and the Commission staff already have in our enforcement proceedings that could be done without dragging down the process and the hearing process further, and maybe we could help in that regard. However, again, I do understand the administrative law judge does have needs to have some flexibility in this case, her rulings. So it may be an opportunity, though, to revisit now that this commission is going to be voting on this item and look at where are we at now, especially since those rulings. There have been a lot of activity, not only in the court but at the commission itself on these issues. Then the other issue is internal audits. I am concerned that by handing over internal audits without clearly defining what exactly is being looked at and how broad that is, that we may be actually chilling the ESCOs from doing their internal audits. I'm not sure what the parameters are, and I'm not sure if there's a way to look at that, and make sure that we are consistent with what we do, not only with ESCOs, but with our own internal audits, as well as internal audits that other companies that come before the commission are also subject to. So I just want to make sure that we are very clear and fair in the same rules applying. And so I think that's something that should be looked at. And with that, I don't have any specific questions. I do want to see, the pathway forward, and I do want to figure out some solutions. And I do hope that there is an opportunity to take a pause and figure out a better collaborative way, especially with the history of past history eons ago of the collaboratives working well. So thank you.
Thank you, Commissioner Berman. Commissioner Alisi? Thank you. So thank you for your comments and questions. We're now going to proceed to a vote. My vote is in favor of the recommendation to reverse that portion of the May 25, 2017 ruling that would have compelled production of responses to 2 of the discovery requests and to deny the other aspects of the appeal as described. Commissioner Sayre, how do you vote?
Aye.
Commissioner Berman?
I vote in favor based on my comments at session.
Commissioner Alisi? The item is approved and the recommendations are adopted. Thank you. We now proceed to the second item for discussion, item 202, cases 15M0127 et al., which is the interlocutory appeal by the Retail Energy Supply Association and Direct Energy Services, LLC, presented again by Julie Bolosky, Deputy General Counsel. Julia, please begin.
Thank you. I'd like to begin by clarifying my response to you, Commissioner Berman, with respect to you saying that this interlocutory appeal deals with the jurisdictional issues. This appeal doesn't implicate the Commission's jurisdiction, except with respect to a very narrow issue on the ESCO profitability, an argument made. But it does deal with the process and the authorization for the evidentiary hearings going forward. So I just wanted to clarify that.
Excuse me, Chair, I just want to...
Please.
It's okay. Thank you. I appreciate that clarification. I saw Paul having a heart attack, so I'm glad that you clarified it. I do agree that we have threshold issues discrete to the administrative law hearing, and that's what we're dealing with, and that is, for me, of prime importance that takes precedent over the other issues that fall after, depending on how you vote on this item. So thank you.
Understood. So this proposed order also resolves an interlocutory appeal. Here, the Retail Energy Supply Association, or RESA, as well as Direct Energy Services, both ESCOs doing business in New York State, challenged 2 rulings issued by the administrative law judges in this proceeding. The first ruling, issued May 15, 2017, rejected procedural challenges to the evidentiary hearings that have been scheduled in this proceeding. In the challenged May 23, 2017 ruling, declined to limit the scope of discovery in these proceedings, specifically rejecting appellants' contentions that data regarding large commercial and industrial customers, and data with regard to ESCO profitability should be excluded from the discovery process. So, as I mentioned with regard to the prior item, discovery disputes on appeal interlocutory relief is extraordinary. And here, although extraordinary circumstances have not been demonstrated given the procedural nature of the challenges, the recommendation here is for the Commission to nevertheless address the merits of this appeal to provide additional guidance to the parties, given the importance of this proceeding and its complicated procedural history. So turning to the first challenge, which is to the evidentiary process established here. Appellants contended that the Secretary's notice, which was issued on December 2nd, 2016, was the vehicle that authorized evidentiary hearings in this proceeding. And as such, they argue that it was issued in excess of the Secretary's authority. Pursuant to Section 11 of the Public Service Law, evidentiary hearings may be held where authorized by law, such as where we have express statutes regarding major rate changes, and we always have evidentiary hearings, or where the Commission otherwise authorizes these hearings. But under Section 8 of the Public Service Law, a specific individual or individuals can be authorized to conduct hearings on the Commission's behalf, but a certification has to be filed in order to do that. So here, because the Secretary does not have such a certification under Section 8, the ESCOs are contending that these evidentiary hearings were not properly authorized. The proposed order rejects these arguments. It acknowledges that the Secretary is not empowered to authorize or conduct hearings, but it also recognizes that she may issue notices of a ministerial nature, as was the December 2nd notice in this case. The notice that is required by law going forward is the notice issued under the State Administrative Procedure Act, which was issued in this proceeding by one of the administrative law judges who has been certified in compliance with Section 8 of the Public Service Law to conduct hearings. But on a higher level, the proposed order also recognizes that although evidentiary hearings were not mandated in this case, by scheduling evidentiary hearings, the Commission is affording ESCOs a greater opportunity to be heard before reaching any decision in this matter. And thus it is surprising that the ESCOs are so vigorously challenging a process that is designed to give them more process than the typical notice and comment procedures would have. Here, where there has been a significant disagreement between stakeholders, including previous failed collaborative efforts, a trial-type evidentiary hearing is the best course to build a record upon which the Commission may ultimately make an informed decision regarding the workability of the retail energy market. Given this fact, and to eliminate further litigation over the authorization of the proceedings up to this point, in the proposed order, the Commission today clearly authorizes a full evidentiary process for these proceedings. With regard to the second ruling, appellants challenge the judge's ruling rejecting the ESCO's attempt to limit the scope of discovery to exclude issues related to large commercial and industrial customers and ESCO profitability. Based on the language of that December 2nd Secretary's notice, which addresses the mass market, appellants contend that the proceeding is limited to evaluating that mass residential market. They also argue that the investigation of ESCO profitability is beyond the scope of this proceeding and the Commission's jurisdiction. The proposed order affirms the finding of the ALJs on the scope issues. Again, interlocutory review of discovery issues should be exercised rarely, and here, the order finds that the ALJs acted fully within their discretion in correctly applying the discovery rules. Specifically, they appropriately held that although the purpose of these proceedings is limited to examining the mass market, evidence related to commercial and industrial products is relevant and helpful to determining whether products successful for large customers could be incorporated into the mass market. They properly found that data regarding ESCO profitability may reveal information relevant to this proceeding, such as overcharges. The order concludes that the question of whether ESCOs can profitably provide valuable service at a reasonable value is crucial to the Commission's investigation into whether the market is properly functioning. Lastly, the proposed order points out that appellants' argument that the Commission lacks jurisdiction to investigate ESCO profitability has been foreclosed by the July 27, 2017 decision of the Appellate Division 3rd Department. In that decision, the Court expressly held that the Commission has broad authority over the gas and electricity market, including the authority to impose limitation on ESCO rates. Accordingly, the recommendation is to deny this interlocutory appeal in its entirety, and in doing so sanction the continued efforts of the parties going forward with a full evidentiary process. Thank you.
Thank you, Julia. Again, I welcome the thoughtful explanation, and I recognize the dual conclusions of the order. One, that the actions by the Secretary in issuing the notice were appropriate, and that as were the actions of the ALJ. And two, that in order to put the issue to rest and avoid further delay, propose that the Commission authorize the evidentiary hearings as described and with the scope as described in the order. Commissioner Sayre?
I've been observing the ESCOs using every legal and procedural move that I can imagine, and I'm a regulatory attorney of some years standing, to slow down and limit this proceeding. All I want to say at this time is that I look forward with very great interest to what the record now, and may I say finally, being developed in this case will say. Even more, I look forward to having an opportunity to make some decisions regarding what appears to be a troubled market. Thank you.
Thank you, Commissioner Sayre. Commissioner Berman?
Thank you. So I have been very focused from the very beginning that we need to be very careful with procedural missteps. Process is very important. And I have been very careful in focusing all of my concerns around that and around the need to look at this and the problems or that may come, or the precedent that may be set for failure to follow the right procedural steps, whether it's FOIL, notices, due process, etc. This extends beyond the ESCOs. It's a threshold issue. And when I voted no on the ESCO order and was very clear that I was concerned that we were making some procedural missteps and that we were trying to through creative logic, explain away what could have been done in a much more procedurally fair and right way, and also making sure that we were dotting every I and crossing every T so that we were not risking a court ruling that would go and say that we had done something wrong. In fact, what happened was the court did acknowledge that we had made some procedural missteps. We don't need to go into the detail of each and every, and basically, for some of that, said, go fix it. We are now doing what I think is strained and creative logic in taking the December 2nd, 2016 notice from the Secretary and saying that it was okay because the court told us to do this. So based on the court order saying go fix it, that is within the tenets of the Commission. Now, we can go back and forth on what's right legally or not. I come down on the side of, especially because there was common ground here between the ESCOs and Council on a very limited matter. That was that there were new members on the Commission and there needed to be an opportunity for the Commission to speak as a whole. That issue to me acknowledges that the Commission as a body is important to speak as a whole, which is why we're here today. I need to make sure that my words are heard for future matters in things, whether it's ESCOs or other matters that come before us. It is very important that we clearly understand the role of the secretary and the role of the secretary as she acts on behalf of the commission, and on the role of the secretary when she issues notices. To the extent that we have had chaotic and confusing and frankly illogical processes for the last few years since I've been on the commission, as it deals with whether the secretary should issue a notice, whether the secretary should start a proceeding via notice, whether the commission itself should act to open up a proceeding. It has not been a clear pathway, and there are no real rules of the road, and it seems like it changes. I implore the chair as we move forward, and I have no doubt that he will be thoughtful in this. I implore the chair to make it clear, not only to the commissioners, but to the staff, and frankly to the secretary, on the specific role and the general rules, and when there may be and need to be exceptions to that. There may be need for the secretary to act quickly, but there may also be an opportunity for the commission itself to confirm that. And I want to make sure that we go through that process and have that discussion, because it's important for not only the commissioners and the staff and the secretary, but it's important for the parties to know what the role of the secretary is. I have spoken publicly about my concerns about the overreach by the secretary. It is no reflection on her. She's an excellent secretary. It is that she does need guidance from the commission itself, so that we are not in the position where we are only seeing notices after they've been published, or we've only seen notices an hour before it's published, and it's not asking us for our blessing on it. There are opportunities and way to get around that, and we need to be clear. So here now we have a notice by the secretary that was done on behalf of the commission without the commission itself blessing it. We had an opportunity at the December 17th, 2016 session before, even though the notice was issued December 2nd, 2016, there was no activity with the administrative law judge's hearing or proceeding until after the December 17th, 2016 session. Nothing had been done except for the notice, and then I think there were some requests for extension that were granted. To the extent that we had an opportunity and we chose, the chair at that time chose not to use that, to have the commission itself take heed of the judge's order and issue this notice and issue the tenets and the four corners of it. I think that was a failure of process. I think that was a failure substantively and procedurally. I think that, and again, I can only think it because we didn't have this opportunity, I think that if it had been brought before the commission at that time, and the question of the four corners of what the scope was going to be, and whether or not we were going to be including C&I customers, we would have had an answer that said no, that was too broad and that it should have been restricted. How do I know that? I don't know 100% because I didn't have that opportunity. But I know it from the comments that were said at each of the sessions by the chair at that time, as well as comments that she said publicly to the ESCOs and to others in the community on her concern and how it was a targeted and very specific focus that was not meant to be overly broad. So, what I would like to see on a going forward basis is that we have that clear pathway and we understand. And to the extent that the commission as a body needs to have the ability to weigh in on things, even if I am in the lone dissent, I want to be able to have that full discussion and opportunity. So that's the first thing. When you look at the Secretary's notice, it is not merely ministerial. It is setting forth in there a lot of policy and a lot of information that goes goes not just to the factual issues, but rather is setting forth policy. That concerns me. Staff said that the notice didn't limit the discovery, and therefore it was broad. That's staff's interpretation. Again, if the notice had been presented to the commission and the four corners of it had been presented to the commission, or it had just been a commission order, I do think we would have seen a very different document and a very different focus and a much narrower focus with disclosure. But again, that's just playing Monday night quarterback. So the order on page 6 says that the Commission's investigation into the roles ESCO play in the state, this is discussing the whether or not the notice was broad, that the presiding administrative law judges considered the Secretary's issuance to be a ministerial act that implements the court's order and advances the Commission's continuing investigation. I think that is illogical, and I think it also goes against what the focus is. The Secretary is supposed to be issuing notices based on on behalf of the Commission itself. To the extent that the court order was focused on the Commission itself, and especially because there had been some procedural missteps, I think it was not only would have been wise, but I think it was incumbent upon folks to bring it to the Commission itself at the December 17th, 2016 session to actually make sure that we were acting on the court's order. And again, I do think that that it would have been different. I do think most likely that the Commission at that time would have, though, authorized the hearing in some fashion. On page 8 of the order, it says that talking about the Secretary's notice, that essentially the Secretary's notice I'm sorry, excuse me, I was talking about the court order. I'm trying to find the part where we say that here there's, in this order, there's been a focus that the Secretary is really giving a heads up to the parties. There was a SAPA issued, and then there was a notice, and that notice was a heads up. I don't think that, oh, thank you. So it says, while the December 2nd, 2016 notice advises parties that there will be an evidentiary track in these proceedings, it is not a notice setting a hearing. Instead, it is an additional notice about process. The Secretary never was or claimed to be empowered to conduct investigations or hearings. In that sense, the Secretary was performing a ministerial function by issuing the notice. The December 2nd, 2016 notice gave parties a head start in the proceeding as to what was to be required. There is an implicit acknowledgement that the Secretary notices are supposed to be purely ministerial. And here, if you read the December 2nd, 2016 notice, I don't think anyone can say it was purely ministerial. Some people can say it. I think this draft order does. That the December 2nd, 2016 notice was purely ministerial. It goes much deeper than that. And really reads more like an order than it does a notice setting forth the parameters based on the order. And to say that the notice was really just giving the parties a head start in the proceeding, I think takes away the importance of notices being issued on behalf of the Commission from Commission order or directives. And while the notice is categorized as being fully responsive to the directive in Judge Swack's decision and order, and while, in fact, the judge may say that it's okay, to the extent that the focus was on the commission itself, I think that's very important. So that's the threshold issue as to Secretary's notice. I think we failed. Therefore, I am not in favor of the approving the draft order in its current form. But then we get into the second piece, which is the scope. I do think that the scope is too broad. I do think that we do need to look at ways that we could make sure that we're not chilling C&I customers, and that we do look at the somehow figuring out a way to make sure that we are addressing the core issue, which everyone is in agreement. The core issue is not about the C&I customers. The core issue is about the residential mass market. And so to the extent that we are not opening the door so broad that everybody is involved that doesn't need to be, I think we need to really look at that. There are some other threshold issues that I think needs to be focused on. There was a July 25th, 2017 letter that came from the ESCOs asking that it be shared with the commissioners. It wasn't expressly shared. I went into the file and looked at all of the documents, and then that's when I found the letter. I do think it is important that items that come in after the draft orders are being looked at and circulated should flag those items that may be pertinent, may not be pertinent to the staff writer, but it is pertinent to the commission, that they have an opportunity, especially when there's a letter that directly asks that it be shared with the commissioners. I do believe that we need to find a better way. I do want to implore the chair as well as administrative law judges that we look at opportunities and we try to figure out a way to move forward. Since we've been focused on this, so what seems to have fallen off from our radar is laser focus on information and updates on what's happening on the enforcement end, as well as how customers are doing. There's been no real discussion on some of the rollout with the court orders, as well as if we're hearing from, at least this commissioner hasn't heard, on if there's been any questions or concerns, not only from the ESCOs, but my primary importance is the customers as well as the utilities and the implementation from it. I do want to track that, do want to make sure that we are looking at it to the extent that a lot of the issues in this hearing are actually being looked at in other proceedings, like the VDR, like the low income collaborative, like some of the working groups. I do think it's important that to the extent that we look at that list, administrative law judges can do that, and those items that are already going to be flushed out for discussion purposes in other pending actions, where there is a lot of robust discussion, there are more players, parties in that. I think that may be appropriate to move some of those items over there if folks are in agreement, especially if the same folks are involved in it. Maybe an opportunity for folks to come to agreement outside of the very, what I would call the siloed evidentiary hearing. I am about to conclude. I do want to just note that what we are not addressing now is some other threshold issues. There may be other things that come, attorney-client privilege, as well as other privilege documents or other privilege requests that come that will go to the front lines with the administrative law judge. And so those may wind up coming before the administrative law judge and needing to rule on it, or somehow coming back to us And so what I don't want to see happen is that if parties, and in particular ESCOs, choose to make sure that they let folks know that they have concerns about this formally and informally, and make their appropriate motions or take their actions, that they're not seen as somehow trying to chill the next steps. That may be in some case, and to the extent that the administrative law judge should clearly try to ferret out those folks who are just looking to delay. But there may be an opportunity where they need to say, we're preserving our right, and these are our reasons why, and try to work through the process. And that's what I'd like to see, where folks are not having to give up their right to work through that. I am very, very concerned, and this isn't before us now, I am very, very concerned with subpoenas getting issued without having the commission have voted on that. I am not sure, at least in my history, I am not sure that I've ever seen a subpoena get issued before. It may be, but to the extent that that is an extraordinary act, I think we need to be very careful, especially when there are subpoenas going to non-parties, and what that means, and especially when the scope is so broad. It may be today that we're subpoenaing ESCOs. It may be tomorrow we're subpoenaing individual customers, and I don't believe that we're going to do that. I would think, and just let me make myself clear, no one has any intent of that. My issue is we need to make sure that we're very clear in the appropriateness of when someone is issuing a subpoena and what the four corners are. I would like to see, if that's going to happen, that there's a general discussion by the commission and a working through what that process would be, so that we're not having staff making that decision without the full weight of the commission. I think that's important from a staff perspective, as well as for parties to know that there is that opportunity. So with that, I thank you. I think that you have done an incredible job of trying to work through these issues. I do believe that there is a pathway there, especially with our wonderful chair, and I hope that we can work towards a better process, and keep in mind that we need to not forego the proper process, especially when it comes to the commission as a body speaking, and it's not just in the ESCO world, it's in all of our matters, and we need to take that very seriously and not sidestep the commission. Thank you.
Thank you, Commissioner Berman, and certainly want to note that we've heard your thoughtful requests to us as a commission and personally to me as chair. Commissioner Alisi?
Nothing more, Mr. Chairman. Thank you.
Okay, thank you. With that, let's proceed to call for a vote. My vote is in favor of the recommendations to deny the appeal and affirm that the pending evidentiary hearings conducted by the presiding administrative law judges are authorized by the Commission as described. Commissioner Sayre, how do you vote?
Aye.
Commissioner Berman?
No.
Commissioner Alisi?
Aye.
The item is approved and the recommendations are adopted.
Mr. Chairman, before we allow Deputy General Counsel Pulowski to leave, I'd just like to point out that this is her last appearance before the Commission, and she'll be leaving our department shortly, and we all wish her well on her new endeavors. And I'm not going to announce where it is because I don't know if that's public or not.
Yes, it is.
But we all loved working with Julia and greatly appreciate her efforts. And I in particular am going to miss her greatly. Okay.
Okay. So thank you, Paul, for that entirely appropriate interruption and for the sentiment you expressed. And are there other commissioners who'd like to?
Thank you.
Commissioner Berman, thank you.
It has been a real pleasure working with you. I have found you very thoughtful, very professional, very diligent, and very, very smart. I have enjoyed getting to know you on a personal level as well as a professional level. You will be sorely missed. You're going to a good place. You and I both used to work there, so I am very excited for your opportunity and look forward to seeing the good things that will come from that. Don't be a stranger, and just know that you've made a difference and a significant difference, and you've touched many people, and I appreciate all that you've done. So thank you.
From the very beginning, you've found your way through difficult, thorny legal thickets. Even in the area, my home turf of telecommunications, you've come up with some brilliant solutions that I never thought of. I've been enormously impressed with your ability and your ability to work with people. And, I wish we could hang on to you.
I just want to say thank you, and I am, it's been a privilege and a blessing to work here. I've learned so much. I'm so glad that I got this opportunity, and I'm going to miss you all. Thank you.
That was well done. Thank you, Paul. Let's move to the third item for discussion. Item 301B, case 14M0101, which is the petition for rehearing and or clarification regarding opportunities for participating in the REV proceeding in utility ownership of distributed energy resources for low and moderate income customers, presented by Ted Kelly, Assistant Counsel. Ted, please begin.
Good morning, Chair Rhodes and Commissioners. Item 301B is a proposed order denying a petition for rehearing or reconsideration of the order adopting regulatory policy framework and implementation plan in the Reforming the Energy Vision case, also commonly known as the Track 1 order or the REV framework order. The Track 1 order established a framework for the development of a customer-centric electric industry where distributed energy resources are deployed by market participants to benefit customers, the electric grid, and society. The Track 1 order applied the general presumption against utility ownership of generation to these distributed energy resources, but identified several limited exceptions to that rule. In particular, one exception provided for utility ownership of distributed energy resources to enable lower and moderate income residential customers to benefit from those resources where opportunities had not otherwise been provided. Petitioners, several nonprofits, request the Commission grant rehearing or reconsideration and eliminate that exception, or limit it to utility funding of rather than ownership of distributed energy resources. They argue that the decision prematurely assumed that markets would not sufficiently serve low and moderate income customers. The draft item clarifies that the exception does permit utility ownership of DER to benefit low and moderate income customers, subject to Commission approval and oversight, and denies the petition for rehearing. The petitioners did not present any legal or factual errors that would warrant rehearing of the order. Furthermore, they do not present any evidence that low and moderate income customers have currently been provided with sufficient access to the benefits of DER through market mechanisms. Therefore, all options should continue to be considered in ensuring that those customers are able to fully participate in the REV energy future, including utility ownership. As stated in the Track 1 order, the Commission will consider each proposal for utility ownership on its own merits and will determine whether utility ownership in any particular case is in the public interest and is necessary to provide the greatest benefits to low and moderate income customers and to further the goals of REV. This careful oversight will ensure that the allowance for utility ownership does not prove a barrier to market developments that enable those customers to be served, including low and moderate income customers, to be served through market mechanisms in DER markets. Thank you.
Mic's not
on. Thank you, Ted, for the clear explanation. I recognize that in the Track 1 order, the Commission had indeed noted that there might be exceptional circumstances where utilities could usefully and appropriately own DER, especially to the benefit of lower and moderate income customers, and recognize the importance of clarifying in this point, in this order, that ensuring service to LMI customers and ensuring these customers' participation in REV is important. So thank you. Are there any comments or questions from my fellow commissioners? Commissioner Sayre.
Utility ownership of DER was one of the most controversial issues in our Track 1 REV order. And we made a compromise between always allowing utilities to own and put DERs into rate base or never. I think we made a good compromise. This order continues to uphold that compromise. And I think, as Mr. Kelly explained, we will very carefully look at each proposed exception involving LMI customers to see if the proposal for utility ownership is in the public interest. I think that's plenty of protection and the right result.
Commissioner Berman.
Thank you very much. So I think this is a unique situation in that there are some issues that we agree with. Ultimately, we don't agree on the most relevant portions. So we all agree, I believe, that we should be clarifying the Track 1 order. What that clarification is somewhat different. I have a different viewpoint. This item we're treating as a rehearing / clarification petition of the Track 1 REV order, which was issued February 26, 2015. I actually was here but did not vote for it as I was excused from the commission session for medical reasons. I do believe that if it had been before us at that time and I was there, I think it may have looked somewhat differently, or at least there may have been an opportunity for me to clarify some points to it. This petition was brought in the relevant time frame for petitions for rehearing and was SAP'd on April 29th, 2015, and comments were due June 15th, 2015. That was over 2.5 years ago from the original order and a little over 2 years from the formal comment period ending. Since that time, there have been many other REV-related orders and building upon this Track 1 order, and these have been issued. There are ongoing numerous proceedings that have been initiated, and many of these issues are being further flushed out in those proceedings. It concerns me that we have taken this up so late, and it's really in some ways very dated, and we've only taken it up. I mean, I'd like to clarify a lot of the aspects, but a lot of the clarification is being done in other proceedings, and some clarifications mean that things stay the same and others they're getting changed. So it does concern me that we're looking at this in isolation. However, at the core of this petition are two issues. The first issue is the issue of what is the appropriate, if at all, mechanism to allow utility ownership of DER for LMI customers. And the second issue is the appropriate amount of public participation and involvement. I was originally going to do this first issue before the second, but I think that I'll take the second issue first. The petition seeks to say we need to do a better job with public engagement. I do believe they're correct. I think that the draft order seeks to point to several avenues of public engagement that was done. They were done. Some of them were done well. Some of them were done great. and some of them were not necessarily done the best, and maybe we do it a little differently. I think that really what for me is at the core is that we should take heed that public engagement may need to be better. I do believe that the criticism is valid in some respects. I am mindful that it's not just about having public engagement for public engagement's sake, and regulatory processes need to proceed with certainty and, when necessary, with regulatory action. And people will differ on what the right amount of public engagement and processes and venues will be. Different people will have different ideas. But we need to be open to the criticism that exists, even if in some cases that criticism may be seen as unfair. In this case, the Track 1 order is now over, but to the extent that we may be able to have better processes, I think that we should look to that. I will say one of the things that I think may be very appropriate to do is to go through the very tedious exercise, not me, but others, go through the very tedious exercise of all of the items in the generic proceeding and try to capture the ones that are still open and where the buckets are. It's very hard to find your way through that if you're looking for a particular rev demo or you're looking for a particular filing that's coming. In some cases, we have done that. We've opened up new proceedings and reflected it in that. I do think that really, while it might be tedious, I think it really would be a great exercise and would show that we are trying to work through that and put the right things in the right place. So I offer that just as constructive criticism and, would even offer up walking through that with people if they want it. So for what that's worth, that's the second prong of the two issues. So now going back to the first issue, which is what is the appropriate, if at all, mechanism to allow utility ownership of DER for LMI customers. Looking at the first issue of utility ownership, the Track 1 order did address it. However, candidly, it was inartfully addressed and seemed to some to weigh on the side of not allowing utility ownership except if there was market failure. Here, the seemingly pertinent language focused on not allowing utility ownership of DER unless markets have an opportunity to provide a service and fail to do so in a cost-effective manner. However, the order was more nuanced than that, and even more nuanced if one was dealing with LMI customers. The LMI exception to the no utility ownership rule focused on no utility ownership of DER for LMI customers unless there does not appear to be a developing market for DER and the public interest warrants utility investment that will support such development. So I've gone through the full file as well as focused on other areas where we have dealt with low income, and there have been numerous areas. In fact, there was several different reports that were issued, several different working groups that have detailed minutes, and I did find it actually very helpful to see the breadth of discussion, not necessarily agreement, but the breadth of discussion. Even in the value DER proceeding, I looked again going forward in the path forward. I see that there is a working group that is going to be looking at LMI and actually LMI and utility ownership and whether it's appropriate. That kind of confused me because we were dealing with that here, we dealt with it in Track 1, and now there's another process. So I really want to make sure that we are making our information available. We're not necessarily spending inordinate amount of times starting from scratch, and that we're having some basic tenets of issues resolved to the extent that initially the Low Income Collaborative was supposed to issue a report for the commission itself to weigh in on. While there was a report issued, there was also a white paper that was not done, and that is being now looked at in the VDR. To the extent that it may be appropriate for the Commission to make some initial determinations on that and find the pathway. It is all over the place. It's very, very confusing. And I do recognize, again, the scope of the issues are difficult, but at the end of the day, our job is to help make a real difference for all customers, and especially those vulnerable and low income. And I really, to the extent that we are doing our due diligence, doing our evaluation and our metrics ourselves, we ask the companies that come before us to do that. We should be ourselves evaluating and measuring and making sure that we are doing things to make a difference from that. So I see it as 4 buckets. The confusion lies in the order. In the first is what is deemed not appearing to be the necessary developing market. The second is what is utility investment. The third is what is an LMI customer. And the fourth, and probably the most important, is what is in the public interest. Now, some groups, mostly environmental and IPNI, would like to bar such utility ownership of DER. Both groups may have different reasons for doing so, but on the face of it, they're in agreement that at this time, there should not be allowed utility ownership of DER. Those groups are not necessarily seen as together on many issues, so I do take note that two large groups that may traditionally have opposing views on this point were very clear. Interesting, the city disagrees. And again, I went through every single filing and looked at everything to make sure that I was fully understanding and capturing exactly what the parties' positions were, not just the summary from staff. So the interesting part is the city's disagreement is on focusing on wanting the LMI customers not to be barred for failure of private entities being unwilling to serve LMI customers, and they should have the same opportunities as the non-LMI customers. So ironically, first as threshold, ironically, that issue is at the heart of some of the separate ESCO issues. So I just found that instructive. But also, the joint utilities opposed the petition because in essence they want the utilities to have an opportunity to serve these customers as well, and they believe that the Track 1 order protects the development of the DER markets, since there's built-in flexibility in the Track 1 order, which would allow a non-utility ownership DER market to LMI customers, as well as a utility investment framework. So their focus is on we can do it as well as have a utility investment framework. So in a nutshell, except for the utilities, almost all of the parties' rationale, it's clear that at first blush, almost all of them would, including the city, implicitly find that it would be best if private entities would be willing to serve LMI customers, would be willing to serve. So the issue is, are they willing to serve, and are the barriers to that? The city doesn't want to preclude such customers from utility ownership DER if there's no willing market participants, and the utilities see that both can, in certain circumstances, exist. So the language then becomes the focus on this utility investment language. Now, the commission order inserted the language utility investment in the order, and the question was it meant to mean more specifically utility ownership? Frankly, I think it's unclear. I do think that the wording utility investment was focused on having, in the section on that, was focused on having our consumer advocate working with stakeholders, including low-income advocates, utilities, and others to develop these utility investment projects in the DSIPs and other ongoing REV developments. So I do think it was not intended to lock in the commission or the staff and stakeholders on exactly what was meant until later. Obviously, therein lies the confusion, and for our purposes, the later is now being called upon for clarification, and the supermajority of the commission that voted for that punt to later are no longer here with us. Truthfully, if all of this only comes into play if there's no market. But even that is complicated on what that actually means. However, since the order also elsewhere focused on utility ownership being banned, except for a few exceptions, including if a DER project would benefit an LMI residential customer where markets are not likely to satisfy the need. So the order focused on utility ownership being banned, except for a few exceptions, which included if the DER project would benefit an LMI residential customers where markets are not likely to satisfy the need. So this exception to the LMI residential customer implicitly understood that the markets were favored. And where the markets are not likely to satisfy the need, the LMI residential customer, should be able to look to, in some fashion, utility ownership. And then it goes on to define ownership as owning, leasing, contracting, or other forms of direct sponsorship. So I am persuaded that the basic underlying premise of the Track 1 order is that utility ownership of DER for LMI customers should be generally disallowed except in very limited circumstances. And the limited circumstances are no utility ownership of DER for LMI customers unless there does not appear to be a developing market for DER and the public interest warrants utility investment that will support such development. Again, it comes back to the 4 prongs. Since the order makes clear there will be commission review of that, one will need to ensure that we're very careful and cautious when we seek to ignore the general rule of no utility ownership of DER. So again, we come back to what I call the confusion elements, or the basic tenant elements, which is 1, what is deemed not appearing to be the necessary developing market, 2, what is utility investment, and we looked at that, and 3, what is an LMI customer, and 4, what is in the public interest. So this is how I would clarify, because again, I think we're all in agreement that there's need for clarification, but there's need for clarification not in a vacuum, because that Track 1 order, again, is dated. Now, it doesn't mean that it's dated and everything goes away. What it means is that we now have the benefit of information, other proceedings, as well as if we were to write that now, how would we have written it? So it's not meant to wipe out the Track 1 order, but it is meant to clarify what it means for as we are dealing with it now. So what is deemed not appearing to be the necessary developing market? We need to be very careful to not give up on the developing market and work with the market participants, low-income advocates, and all stakeholders to define what barriers exist to such markets. As we see in item 301A that we'll be addressing later, there is a robust dialogue and folks, not only the parties here who sought to have no utility ownership of DER, but others including SIA and Vote Solar, who were also not willing to give up on the developing market, as well as the city. But I will address that aspects of whether it appears to be the necessary developing market in 301A. The second prong is the what is utility investment. Here, that's a broad definition that was meant in the order to be decided for another time. To extent it can incorporate utility ownership, I understand that. I do not think it was meant to help with focused on not giving up on the market. So to extent I think this is the key. I think that that section that dealt with utility investment and looked to the consumer advocate working through it in other rev avenues, including DSIPs, was meant that to the extent something less than utility ownership should be tried first or incorporated with that, that was what the focus was. It was allowing, if necessary, utility ownership, but it was really looking at it from a very targeted and limited perspective, and utility investment was meant broader, and there might be other opportunities. And the one that comes to mind to me is the financing aspects with the New York Green Bank, et cetera, because it's about, if you look at the low-income collaborative report, not the white paper because that hasn't been done yet, but the report identifies different barriers, including financing, and that also is dealing with some aspects in the credit risk and other things. So to the extent that I think there was a recognition from the Track 1 order as well as and the low-income collaborative that opportunities for financing and other things may be appropriate. I think that's what it was trying to get at, that utility investment that might need to be there. And again, working with the market to the extent that you can. So the third thing is, what is an LMI customer? I agree with the parties that say that the LMI customer is not clearly defined in this context and is too broad, that it virtually makes it meaningless. I do think the commission captured that broad definition for this without much thought behind it, and was intended to make it more palatable to a broader set of folks and to deal with it later. However, to the extent that we should be looking at this in phases and whether or not we need to limit it to low-income folks, we can look at that in the 301A matter. The fourth aspect is, what is the public interest? And I'm mindful that we need to be very careful that any allowance for an exception to the general rule that no utility ownership of DER needs to be in the public interest, and that does include trying to ensure that there's a vibrant and cost-effective market. And again, to the extent that we'll look at that in 301A, whether or not there is a market. In conclusion, as to the LMI exception issue, I would grant rehearing and reaffirm that generally utility ownership for DER should not be allowed. There are aspects of the order that dealt with the LMI part that were inartful and inadequately captured the intent and left things for later. I would not seek to neatly address now in a Track 1 order clarifying and saying it's okay, and rather I would say that since here the Track 1 order clarification is being inexplicably looked at over 2.5 years later to clarify, I don't think, frankly, that this is the proper venue for the commission now to speak. Rather, I would look to the value of DR proceeding that has the LMI working group, and we'll be looking at the white paper, and it's also considering some of these very issues. And I would look to other opportunities, and again, the 301A is one that comes to mind. And finally, the remaining aspect of the petition, okay, that was the second issue, so we dealt with that. So overall, I would grant the rehearing. I do not see that we're locked in forever to the Track 1 order in and of itself. We need to learn from that, and that's part of what has been the different phased approach, and looking at things and making sure that we're on track, and if there needs to be adjustments that they're made appropriately, but also trying to do things in a very constructive and forward thinking way, I think is appropriate. We are in agreement that the Track 1 order needs clarification. We're just in disagreement on what that clarification should be. And as the clarification order is now before us, to the extent that I'll look at the 301A order moving forward on what is appropriate, rather than just solely the rationale that the generic track 1 order allowed this exception. So I'll be voting against the draft order that's presented, but I do thank folks for their thoughtfulness in this, and I do know that we will be revisiting a lot of these issues in a way to make sure that they make sense. So thank you.
Thank you, Commissioner Berman. Commissioner Alisi? Okay. Thank you. With that, I call for a vote. My vote is in favor of the recommendations to deny rehearing and provide for clarification, and to provide for clarification as described. Commissioner Sayre, how do you vote?
Aye.
Commissioner Berman?
No.
Commissioner Alisi?
Aye.
The item is approved and recommendations are adopted. Move now to the fourth item for discussion, item 301A, case 16E0622, which is the petition of Consolidated Edison Company of New York, Inc., for approval of a pilot program for providing shared solar to low-income customers, presented by Marco Padula, Deputy Director for Market Structure. Ted Kelly is available for questions. Marco, please begin.
Thank you. Good morning, Chair Rhodes and Commissioners. Item 301A is a draft order addressing a filing by Consolidated Edison Company of New York, Inc., seeking approval of a pilot program for providing shared solar to low-income customers. In its petition filed on October 31st, 2016, Con Edison seeks approval of a shared solar pilot program to provide community distributed generation to customers participating in the company's established electric low-income affordability program. The shared solar pilot would provide low-income households with opportunities to participate in clean and renewable energy offerings. The company proposed that the shared solar pilot would consist of 2 phases: an initial phase to test the pilot program, and a second phase expanding the pilot if it proves to be successful. The draft order before you, if adopted, would approve only the first phase of Con Edison's proposed pilot, allowing Con Edison to competitively procure the design, siting, permitting, construction, and commissioning of 3 megawatts of solar generation. The solar panels will be installed on company-owned rooftops and other company-owned locations. Con Edison plans to prioritize the installation of the solar generation in areas where additional distributed resource penetration may benefit the system, and therefore benefit other customers through a reduced need for traditional infrastructure investments. Any program expansion beyond the first phase will require future approval by the Commission. The 3 megawatt project size will enable the company to provide an average $5 per month monetary credit to up to 1,600 participating low-income customers. The draft order finds that Con Edison's ownership of the 3 megawatt solar generation project is warranted under the exceptions to the general rule against utility ownership described in the Rev Track 1 order. Specifically, the exception which states that a project will enable low or moderate income residential customers to benefit from DERs where markets are not likely to satisfy the need. In this case, the draft order grants Con Edison ownership in response to the current lack of opportunity for low-income participation in projects like this, and as such, will provide experience with a model for low-income participation in DER programs. I would note that the draft order also expressly states that this decision is not a precedent. Specifically, the shared solar pilot would provide an opportunity for participation in DERs for low-income customers, which to date has not been provided by markets in Con Edison's territory. The shared solar pilot will enable the company to understand how low-income customers respond to various program design features, and allow the company to explore and report the most effective roles for the utility, third parties, and community organizations in providing these customers access to DERs. Lastly, in addition to various reporting requirements, the draft order requires Con Edison to develop an implementation plan in consultation with staff, which will be submitted back to the Commission for Commission approval. This concludes my presentation. I'm available for any questions.
Thank you, Marco. Thank you for the very clear discussion. I would like to note several things here. Obviously, I note the concordance of this proposed project with the item we just discussed, the around the LMI exception. I note the cautious approach here, the scale, the limited nature inherent to a pilot, the phasing, the filing of an implementation plan subject to Commission approval, all in response to an absence to date of market or other solutions. And I also note the attention in Con Ed's project planning that will be given to system benefits resulting from appropriate deployment of the resource. Those conclude my observations. Commissioner Sayre?
I fully concur with the chair's comments. I think Con Ed made the case that this pilot is in the public interest, and I have the same view of the program as Chairman Rhodes. It's limited, it's cautious, it involves further steps for Commission approval of the implementation plan. I think this is a good news story.
Commissioner Berman?
Thank you. I do recognize that 301B was voted on, and so that now has to be factored into the 301A order that's before us. I do want to note that it wasn't just about the Track 1 order. It also looks to the community net metering. And in July 2015, the Commission issued a order that established a community net metering in the state. And the community net metering allows multiple customers to subscribe and receive credits to the electricity produced from on-site renewable generation facility. And the policy was done to make it possible for primarily renters and low-income residents and homeowners to receive credits for renewable energy who previously could not install a renewable generation facility in their home. And in general, the Community Energy Project was deemed in July 2015 to require a minimum of 10 members. In March of 2017, the Commission, in recognition of the work that had been done through the Community Net Metering Low Income Collaborative, in there it listed out several different barriers to community net metering. There was a concern from folks that we were not moving forward fast enough with community net metering, and that one of several barriers dealt with the 10-member requirement. So the Commission, in limited fashion, myself included, waived the minimum 10-member requirement in some areas. And so the community net metering was divided also into two phases. The phase one which was till April 30th, 2016, which was supposed to be an introductory phase. And then during this period, the projects were limited to siting distributed generation in areas where it provides greatest locational benefits to the larger grid and in areas that promote low-income customer participation. And then the second phase, which was to begin in May 1st, 2016, when the community net metering projects will fully be implemented and deemed to be implemented throughout the other utility service territories. There have been some applications in the Con Ed territory. I believe that there were 10 CDG projects. I don't believe that any have gotten off the ground. Is that correct?
I believe it's correct that none of them are in operation yet, and
Right.
10 sounds as
Okay.
either correct or close to correct. Yes,
And none of them deal with the low-income community. Is that correct?
that's right. To our knowledge, none of them are focused on lower moderate income customers.
Okay. So here, the focus really is in has there been a failure? And again, the focus is on the low-income DER customers and whether or not there's a sufficient market that is existing. And if not, then the Commission, based on 301 B, believes that utility ownership of DER for low-income LMI customers may be appropriate. And so that is now before us in what is the market. Is it not sufficient enough? And part of the concern that I have is that again, we have multiple parties who might normally be not on the same page, and here are very afraid that we are foregoing the market without giving it a sufficient chance. And most of their focus has been on that it's premature, that there are other areas that we're looking at, that the Low-Income Collaborative, as well as the VDR, and that there has been, and frankly also the ESCO proceedings were making it hard for folks to commit. And so there was concern that we would rush into utility ownership of DER, and then there would never be an opportunity for the market to develop because the utility has taken over. I think that's primarily the bulk of the concern is that we're rushing into this. This shared solar pilot and the draft order has tried to make it take the very cautious approach, and to not, we are not saying that there is market failure. What we are saying is that we are making this a pilot that should be instructive in working with the different folks to give information that may be helpful not only to the utility but to the customers and to those market participants, so that if there are barriers that are making folks unable to come and have active projects, that we should try to identify that. So I do think that one of the things that's helpful here is that we are not, after today, allowing the utility, in this case Con Ed, to rush ahead and do a very broad program we are limiting it, and we are telling them that they must come back to the commission as a whole with their implementation plan. And that implementation plan must be very clear in some of the goals that are going to be done and some of the actual details in flushing that out. So it is trying to have an opportunity for folks, frankly, like was done with BQDM in many respects, to be able to offer their thoughts on the implementation plan, to be able to offer some constructive criticisms, and to also, again, look to ways to enhance the market in a way that may then be able to have the utility get out of the way later, or be able to understand some of those developments. This is one small tool in the toolkit. There are many other aspects that are out there. I think this draft order, makes very clear that the market is important, that this is not now a signal to all utilities to go rushing ahead, that instead it is really looking for some clear guidance through this pilot to try to actually entice folks to this. We do have an issue that we have wanted to have CDG as a whole, and also then for low-income customers, and we need to help unbottle the issues, but in a way that is not forgetting about the market, but rather is trying to embrace that. So I can be in agreement with this item. First, the threshold issue is the 301B decided the threshold issue. But then second, because it is very narrow, and when folks see the draft order, they will see, I think, the careful and cautious approach that's being taken. But for me, also, what's most important is that the Commission as a whole is trying to work through this, and that the implementation plan will come back to the Commission in this case. Doesn't mean that in other cases, in all cases, that will be done. But for right now, it's very important that the Commission weighs in on this. And I think just like the 301B, as well as the initial Track 1 order, there was a very clear recognition that the Commission itself needs to review the exceptions to the utility ownership of DER, and this is following those basic elements. And I give credit to the staff willing to work through this. I know we've had many internal challenges with me on making it as carefully and narrowly focused, and again making sure that we are clearly trying to help not say goodbye to the markets, but actually to embrace them and look at the other barriers which may need to be taken up in other proceedings. So thank you very much.
Thank you, Commissioner Berman. Commissioner Lisi? Thank you. With that, I now call for a vote. My vote is in favor of the recommendations to approve the first phase of Con Edison's shared solar pilot and direct the filing of an implementation plan subject to Commission approval as described. Commissioner Sayre, how do you vote?
Aye.
Commissioner Berman?
Aye.
Commissioner Lisi?
Aye.
The item is approved and recommendations are adopted. We now move to the fifth item for discussion. Item 302, Case 17E0428, which is the investigation into the April 21, 2017 Metropolitan Transportation Authority subway power outage and Consolidated Edison Company of New York, Inc.'s restoration efforts, presented by Mike Warden, Director, Office of Electric, Gas, and Water, and Paul Agresta, General Counsel. Mike, please begin.
Good afternoon, Chair Rhodes and Commissioners. Item 302 is a draft emergency order in which the Commission would direct certain steps be taken to safeguard and maintain the New York City subway system. As you know, in recent months, increasingly frequent power outages have led to failures of infrastructure throughout the Metropolitan Transportation Authority's rail and subway systems. Staff's investigation into the quality of Consolidated Edison's power supply to the MTA system began as a result of an April 21, 2017 power failure that led to significant delays across MTA's subway system. The April 21st outage resulted from a failure of Con Edison's electricity supply to the 7th Avenue subway station. This in turn led to a loss of subway signals. It was also determined that one of the secondary services to that MTA facility had been previously rerouted, and Con Edison's failure to document the change in its records significantly delayed repair of the electrical systems after the outage occurred. The initial results of our investigation indicate that there are significant actions that Con Edison should be taking now to improve resiliency and prevent future service failures. First, Con Edison needs to dedicate additional personnel and perform comprehensive inspections of all electrical equipment that serves the MTA system, including equipment in its own manholes, MTA's interlocking station equipment, and area substation equipment serving MTA's high-voltage substations. Second, MTA needs to install new sensors and monitoring equipment throughout its system, including advanced metering infrastructure and associated communications networks. Third, Con Edison needs to replace all aluminum conductors that supply MTA signaling services with copper cable. It needs to install redundant electric supply options for MTA signaling services, and it needs to design, install, or modernize automatic transfer panels and related equipment. Fourth, Con Edison needs to establish a stockpile of emergency generators that can be used to respond quickly, on demand, across all MTA stations, and support the establishment of quick connects and other equipment needed to deploy the generators. Fifth, Con Edison needs to perform a complete, detailed failure analysis of all power supply and power quality events affecting MTA signaling services. Sixth, Con Edison needs to establish a dedicated operations response team and participate in activities of the MTA's crisis response team and joint emergency drills. Seventh, Con Edison needs to assist in the performance of a detailed power quality assessment. And finally, Con Edison needs to prepare a project management plan to coordinate all of its activities related to the MTA system and track its performance and expenditures in this remedial effort and provide monthly reports on its activities to the Commission. This is just a summary of some of the activities that need to be done. I would report that DPS, MTA, and Con Edison technical staffs have been communicating extensively on the details of the scope of the remediation measures that are necessary. Our expectation is that Con Edison will provide the necessary resources and its full cooperation to the Commission, the staff of the Department of Public Service, and the staff of the MTA in ensuring the remediation, maintenance, and repair of electricity service provided to the MTA. That completes my part of the presentation. Paul will now address the procedural aspects.
Okay, I have just 2 points that I want to mention. The first is that the draft order notes that Con Edison has consented to the ordering clauses. I just want to explain that that does not mean that this is a joint proposal or a settlement agreement. It means that Con Edison is working with staff and has indicated that it is trying to fully cooperate with the attempts to do what this order is attempting to do. The proposal is before you is not a joint proposal. It's the chairman's proposal with the assistance of staff. The other thing, before I go on to the second one, I'd like to also say that we've been working very hard with Con Edison, and at least my experience in working with them on this effort has been that they've been very responsive and cooperative, and I want to thank them for that. The second thing I want to point out is that The proposal is adopted on an emergency basis. What that means is that there isn't enough, this really needs to get done now, and there really isn't enough time to put it out for comment and wait for the comments before you act. When you adopt something on an emergency basis, you then will follow it up with a notice published in the State Register, a consideration of comments, and then this order will expire on its own within 90 days. And once the comments come in and you've considered them, you will have to again consider whether you want to further adopt the rules that are proposed here. And so we expect that we'll be back in a couple of months to do that process. And that's all I have for, unless there's any questions.
Thank you, Mike. Thank you, Paul, for the summary of where we are, what we're doing, and the process involved. I certainly appreciate the importance of the investigation described by Mike. I also appreciate deeply the fact that we face a crisis and indeed a declared state of emergency. It's clear that electric power issues on the combined MTA Con Ed systems are part of the problem, and that they can result in costly and dangerous disruptions to service, which means we really have to take swift and effective action and help all partners also take swift and effective action. And I note with appreciation Con Ed's consent to the work described, summarized by Mike, to its cooperation in the work and into its initiation already of good parts of the work that are described in Mike's summary. Commissioner Sayre?
I just want to say that I'm fully in accord with the item and with the chair's comments.
Commissioner Berman?
Thank you, Chair. Because of the extent of the problem, depth of public concern, including the issuance of an executive order from Governor Cuomo, Chair Rhodes directed staff to initially investigate the matter as it concerned both Con Edison's power quality and power supply to the MTA system. Staff, under the direction of Chair Rhodes, worked with both the MTA and Con Ed to try and determine not only the issues which led to the relevant outages, but to determine what needs attention to protect the safety and general welfare of the public as it concerns the reliability and resiliency of the power connected to the MTA subway system. We at the Commission have very limited information at this time. We're now being asked, based on staff reporting, an initial careful review from Chair Rhodes and as a chair proposal and as evidenced by his letters to Con Ed, to allow a further 90-day review. This review is in looking at the past and in looking forward and clearly identifying, making sure that we are focused on making sure that we have the information to try to prevent any future events. The focus is on Con Ed, MTA, and DPS staff continuing to work cooperatively to identify what needs to be done to safeguard and maintain adequate utility service to the subway system operated by the MTA. We as the Commission are not here in this order and at this time determining faults or assessing the proper cost allocations. Rather, we are authorizing this continued investigation as well as giving the specific framework with targeted activities and short timeline deliverables necessary to properly undertake this endeavor. This includes ensuring relevant experts such as EPRI and personnel are on hand to help with this important matter. This matter may come back to the Commission within 90 days of the issuance of this order, and at that time, if there are any issues in dispute or needing further clarification or detailed next steps, we can address them at that time. What is most important is that the technical, on-the-ground engineering and power resiliency folks are actively engaged in identifying root causes and solutions to power quality and supply events to avoid or minimize future events. To that end, the upcoming joint response drill activities are imperative. I would ask that such response drill activities involve, as appropriate, emergency responders, including the FDNY. I have comfortable voting in favor of this item and ask that staff at DPS and Con Ed to continue to keep at the forefront that safety is everyone's business and we must work together to find solutions. Thank you. I'm in favor of this.
Thank you, Commissioner Berman. Commissioner Lisi?
Thank you, Mr. Chairman. This is very encouraging for me. I find this forward to improve
Commissioner Alisi, I'm sorry to interrupt you, but can you turn on your microphone? The green button. Thank you.
How's that? Okay. Well, I am encouraged by this, to say the least. I think for the average citizen to pay attention to this from somewhere outside of the metropolitan area, it's intriguing to me, and I'm encouraged by the actions that are here before us as an opportunity to improve the quality of life in the metropolitan area, to improve the safety of those people that use the MTA, and of course for the economic health of the city itself as well as the state. And I look forward to whatever public input comes in the future as a result of this, and I'll be supporting this issue.
Thank you, Commissioner Alisi. So now I call for a vote. My vote is in favor of the recommendations as described. Commissioner Sayre?
Aye.
Commissioner Berman?
Aye.
Commissioner Alisi?
Aye.
The item is adopted and the recommendations are approved. We move now to the sixth item for discussion, the final item for discussion. Item 303, cases 15E0250 et al., which is the petitions of Pareto Energy Limited, presented by Bridget Wobe, Assistant Counsel. Bridget, please begin.
Thank you, Chair. Good afternoon, Commissioners. Item 303 is a draft order that responds to two related petitions filed by Pareto Energy Limited. The first was a petition to implement a microgrid business model as a least cost resource to meet reliability contingencies and demand management objectives at Consolidated Edison Company of New York. It was filed on April 10th, 2015. The second, a petition for rehearing, was filed on April 10th, 2017. Repeats Pareto's 2015 requests, but is styled as a petition for rehearing of the Commission's March 9th, 2017 Order on Distributed System Implementation Plan filings, or DSIP filings. The petition for rehearing alleges that the Commission committed errors of law and fact per Public Service Law Section 22 and the regulations implementing that statute. The 2015 petition seeks relief from the Commission, including establishing Pareto's proposed microgrid business model as eligible for funding as a least cost resource for meeting reliability contingencies and demand management objectives under 3 separate funding opportunities. And it also requests that the Commission direct Consolidated Edison to interconnect 2 microgrids using the petitioner's non-synchronous interconnection technology, which it markets as GridLink. Pareto intends to implement this GridLink technology at the Kings Plaza Combined Heat and Power Project located in Brooklyn and at the Kennedy International Airport cogeneration facility located in Queens. The petition for rehearing alleges that the Commission's order on DSIP filings erred factually and legally by not considering certain technologies, namely its GridLink technology, and that the utilities violated the law by not adopting these technologies. By this order, the Commission denies Pareto's petition and denies Pareto's petition for rehearing. The order makes clear that Pareto is encouraged to continue to pursue viable funding streams to develop its GridLink technology to maturity and to continue to engage in the New York market, but the relief requested by these petitions is an inappropriate attempt to bypass available utility programs and obtain funding. Staff and I are available if there are any questions.
Thank you, Bridget. Welcome the summary. I appreciate the legal analysis. And I also note the well-made point that the Commission should refrain from interfering in appropriate, effective selection processes, in this case by NYSERDA and or by Con Ed, in determining which specific projects to select as part of a broader program. I think that's an entirely appropriate restraint. Commissioner Sayre, any comments from you?
Although it's fairly clear in the order, I guess I want to make it additionally clear that in this decision we're not rejecting the use of the company's proposed technology, and in fact I hope sometime in the future it will get a trial. All we're doing here is saying that the company has not made a case for us to require the use, ultimately at ratepayer expense, of this technology. It's as simple as that. So I urge the company not to abandon its efforts and continue to work with utilities and other potential partners.
Commissioner Berman?
Thank you, Chair. Here, petitioner essentially, among other things, seeks for the Commission to mandate Con Ed to interconnect its grid-link technology. This situation is complicated because the matter overlaps with numerous economic opportunities for petitioner to be a part of. This includes New York Prize, standalone microgrid projects, REV demos, non-wire alternatives, DG interconnection opportunities, and dynamic load management programs. I am truly sympathetic to petitioner here. A few years ago, they were awarded with much excitement a state grant related to the Kings Plaza Brooklyn Microgrids project, and it appeared to petitioner that all systems were likely to be a go. Petitioner spent considerable time working with numerous folks, including Con Ed, DPS, NYSERDA, and near the end at the ISO. It is disappointing to petitioner to date that it does not have a viable active project and feels that NYSERDA and other state energy processes have been a barrier to competition. We do need to take seriously allegations and concerns that our energy processes are barriers to success. However, this petition is not the right venue. We should not be in the business of picking the winners and losers, and thus we can't direct Con Ed to select a petitioner for its REV projects. However, it is something we need to review globally in the future to work with all parties to ensure we are getting rid of any perceived unfair regulatory barriers. I support denying this petition, not necessarily for all the reasons outlined in the draft order, but rather for the limited reasons that the petition is denied without prejudice for petitioner to seek and obtain funding in the future, and to encourage petitioner to work, if it still desires, with Con Ed to move the interconnection process forward for the Kings Plaza project. Thank you.
Thank you, Commissioner Berman. Commissioner Lisi? With that, I move to a call for a vote. My vote is in favor of the recommendation to deny the petitions as described. Commissioner Sayre, how do you vote? Aye. Commissioner Berman?
Aye, with based on my comments at session.
Thank you. Commissioner Alisi?
Aye.
The item is approved and recommendations are adopted. We will now move to the consent agenda. Do any of my fellow commissioners wish to recuse from voting on any items on the consent agenda? Seeing none, I call for a vote. My vote is in favor of the recommendations on the consent agenda. Commissioner Sayre?
Aye.
Commissioner Berman?
Aye.
Commissioner Release?
Aye.
The items are approved and the recommendations are adopted. If I may have your indulgence for one more moment, or Commissioner Berman, can I turn that over to you?
Sure. I had the pleasure yesterday of spending time with the gas safety staff at the Commission, as well as about 130 people, ranging from folks from PHMSA, fire departments, fire chiefs, state fire department, utilities, other companies dealing with gas safety, as well as some miscellaneous folks involved in the gas safety space. I had that pleasure with the support of Chair Rhodes, to be a part of working on a all-day focus on what we need to do to continue to work through gas safety issues and improve gas safety. Coming up on August 11th is Call 811 Day. It's very important that we focus on that, but also focus on our first responders and how we can work with them as partners in embracing all that we do, so that we can try to reduce and have zero incidents, but also to help in the planning of it and work through that. We were really blessed that the Georgia Public Service Commission sent to us someone who is nationally recognized, who's in the audience. Michelle, if you just stand up. She is really, a mover and a shaker, not only in Georgia but nationally, and has been recognized in Georgia itself in a groundbreaking program called the Georgia Pipeline Emergency Response Initiative Project. So she came from Georgia, not at the expense of New York, to share with us, their stakeholder involvement and things that are working, and to give us an opportunity to, in this group, the small group of 130, where we moved to a larger room, to talk about these issues and make sure that we are continually engaged. And we were blessed to have many folks there, and a lot of the issues on mutual aid and planning. And frankly, really, for me, it actually informed me on why, especially with the Joint Response Initiative with the MTA, why it's important to make sure that we have at the table those first responders like the FDNY, which is why I pointed it out here as well. So I thank you. We're doing a lot of amazing things in New York on gas safety. We're working hand in hand, and it helps us to make sure that we continue to do that. So I'd ask everyone to do their part and help us continue to have a wonderful energy system with natural gas that is safe, adequate, and reliable, and that starts with safety. So thank you so much.
Thank you, Commissioner Berman, and thank you, Michelle, for coming, for joining us. Assistant Secretary Icey, is there anything further to come before us today?
There are no further items today, and the next session of the Commission will be held in Albany on September 14th.
Okay, thank you, and with that, I adjourn.